the core of women's freedom involves squelching religious institutions' freedom to say no to the HHS mandate. And if you look at the literature on women and religion across, frankly, as much as they've been able to measure it with data for, say, 100 years and with anecdotal evidence from 100 years prior, some ranging beyond anecdotal, women do tend to practice religion on average more than men. And women regard it as, they place it higher in their hierarchy of values. So it is very dangerous to see them posing the notion that religious freedom is against women's freedom. I'm also working at the UN for the Holy See on this, and it's a huge international theme, not just a national theme.
Thanks, Helen. Well, Jim, as one of the newer members of the world's greatest law school at Stanford,
now it is.
And embarking on what is a marvelous project with this new religious liberty clinic, the only one of its kind. As you look out there, what do you see? How would you gauge the most discouraging sign you've seen with respect to religious liberty?
Well, I think on a discouraging note, I think there are two dynamics. One's legal and one's cultural. And I think we all understand that. Certainly from a legal perspective, the HHS mandate challenge. You look at as Helen said, the government's argument in Hosanna Tabor, I think was particularly alarming. And just because we got a 9-0 decision, I think, yes, it's a great legal result, but still worrisome in terms of what the vision that some have for the limitation on religious liberty. In the kinds of cases that we do at the clinic, the point of the clinic, as you all are probably familiar, is to train law students to know not only how to think like a lawyer, but to be a lawyer. And so we have real cases, and the cases that we take tend to be smaller scale cases that work within the system for teaching students. And we see in a lot of our cases, on a smaller level, on a local level, an administrative indifference, whether it's in response to NIMBYism in land use cases or in prison cases. And I think that reflects the second half, which is cultural. And I don't necessarily have an answer to the cultural problem, but I think to the extent that we've lost as a culture the sense of religious liberty as something that is not just a historical accident. Oh, it just happened to be important at the founding of the country and somehow it got into the Constitution, but that it's a universally important value of who we are as human beings. And I think we can see that in the lack of outrage over some of the religious liberty challenges that we've seen. We see it in the political realm. But so I think that ultimately a lot of these answers are going to come from the cultural side. John Garvey, president of Catholic University, gave a talk recently where he emphasized, look, religious liberty is very important, but if we've lost religion, we lose the ability to effectively communicate why it is that this is something that's important, that it is a civil right akin to gender or race or other things that people get intuitively, and I think it's important to build that conversation.
It's interesting, if you listen to what our panelists have said even thus far, it's apparent that the challenges to religious liberty are really arising out of our culture. That's a particularly disturbing concern, I think. Well, Jeff Moon, with the U.S. Conference of Catholic Bishops, if you had a magic wand and could reverse or change a single U.S. Supreme Court decision that affects religious liberty, what would it be?
First of all, thank you, Elder Wickman. I appreciate being here. Given that I'm sitting here next to Vaughn, I'm going to resist the semi-obvious temptation.
Don't hit it.
To say, well, he's bigger than I am, so I'm not going to do it. To say anything about Smith, and I won't. Let me raise kind of a dark horse case, though, that is one that has particularly rankled me, and I'll say parenthetically that I wrote the U.S. Catholic Conference's amicus brief on the case. And so there's a sort of personal involvement here, but I also think it is dramatically badly decided. And that's a case called Locke versus Davey that I think most of you know about. Locke, just very briefly, is a case which basically decided that an individual student who was entitled to the benefits, college student, who was entitled to the benefits of the so-called Promise scholarship program, which a state had provided, which provided assistance for students who fell into certain categories, had done, were in the top 10% of their student body, graduated from a public high school, to assist them to go to college in their state. And it provided assistance that could be used for literally anything. It could be used to pay for books. It could be used to pay for courses. It could be used to pay for religion courses. There was no limitation on how the benefits could be used, except that the Promise Scholarship was lost to any student who decided that he was going to study for a degree in pastoral ministry. And that's what the individual plaintiff did. He changed his major to a major in pastoral ministry. And the instant he did that, he lost his eligibility for the Promise Scholarship program, and despite the fact that if he had remained, let's say, a business administration major, could have used Promise Scholarship funds to pay for religion courses, to pay for courses in ministry, to pay for courses in history of religion, to pay for courses in preaching, for example. He could not get the Promise Scholarship because he had declared that major. And it seems to me that if that's right, then Church of the Lukumi has to be wrong. It means that government can treat the same conduct, like, for example, killing a chicken, paying for a class, in a different way based on the personal religious motivation of the actor. And I think that's something that is really, really very threatening. When Elder Wickman posed this question, one of the ways that he posed it was, and if you could change its holding, what would it be? I would say something, as the last sentence in my opinion, something like, when government broadly accords a public benefit paid for by the taxpayer, government cannot constitutionally decide to withhold that benefit based on the personal religious motivations for the use of that benefit that some individual might have. So I think I have to say that, leaving Smith aside, I think Locke is both a very bad precedent, and it means something that I think is dramatically threatening about both the power of government and the way that it's used.
Thank you, Jeff. I think Jeff's answer highlights one of the challenges that we face, and that is what is the proper balance between government and religion, and religion in the public square, which is sort of in my view, a close sibling to that issue. I'd like to turn now to Eric Baxter and ask him essentially the same question that Jeff just responded to. If you had a magic wand and could reverse any U.S. Supreme Court decision, what would it be and why?
Thank you, Elder Wickman. Pleased to be on the panel today. I guess now that Smith is off the table, I think that was the obvious choice for everyone. I wanted to follow up on Vaughn's statement that I think that there is, the magic wand may be the upcoming treatment of that case. At the Beckett Fund, we have several cases where we're dealing with this issue of general applicability, and I know there are some non-lawyers in the audience. The concept, a lot of courts have read the concept of neutrality and general applicability as saying, well, as long as you didn't intend to hurt religious conduct, that makes the law neutral and generally applicable, and they've kind of conflated those two standards. And there are a number of cases now pending in the lower courts where there's an opportunity for the Supreme Court and the lower courts to put some teeth into this idea of general applicability, that if you provide exemptions from the law for various reasons, that any single exemption means that you also have to exempt religious liberty if there's on religious liberty grounds. If there's reason to give a secular exemption, then there's really no excuse for not also giving a religious liberty exemption. And we see that in the HHS mandate cases right now, where the law supposedly is generally applicable in that all employers are required to provide coverage that includes coverage of contraceptions and abortion-inducing drugs and sterilization. But in reality, because of small employer exemptions and grandfathering clauses, almost a majority of employees in the United States who receive their insurance through their employer are actually not protected by this law. They are not entitled by the law to have the coverage, and so the concept is that as long as there's been that exemption, and even if it were just a much smaller exemption, that there must also be a religious liberty exemption allowed. So I think that may be the magic wand in that case as we go forward, fighting for that concept and putting some teeth into the principle of general applicability. The other case I suppose that I would mention is the Boerne versus Flores case, where the Supreme Court said that RFRA could not be applied to the states. And so now you have a system where under RFRA, you have the pre-Smith protection available against federal law, but at the state level, you are only protected if you can show that the law is either not neutral or not generally applicable. And so if I had a magic wand, I suppose I would reverse Boerne and have allowed the federal government to impose the RFRA standard on the states.
Thanks, Eric. In fact, the mention of the Flores versus City of Boerne case is a good transition to, and Eric's answer is a good transition of another area that I thought might be worth talking about. The Religious Freedom Restoration Act was adopted by Congress really in response to the Smith decision. It was an effort to put back into the law the compelling governmental interest, least restrictive means test, and which had pre-existed Smith, so that when a government rule or regulation comes in conflict with a religious practice, that under that standard, that compelling governmental interest standard, the burden was on the government to justify the rule over the religionist, and the standard was a rigorous one. It had to show a compelling governmental interest and that it was being pursued by the least restrictive means. As Vaughn spoke about the Smith case, Smith, of course, changed that and basically said that the burden was now on the religionist, and that if a law was neutral and generally applicable, that the government rule would triumph. And so RFRA was adopted. It attempted to reinstate that compelling governmental interest standard and applied it to both the states and to the federal government. It's still applicable to the federal government. But in the Boerne case, the Supreme Court held in a case arising down in, as I recall, down in San Antonio, where there is a Catholic parish building. Am I right about that, Jeff? That was in a historic preservation area. The parish priest wanted to, and the bishop wanted to increase the size of it because of the need to accommodate their congregation, and the local land use authority said no, and ultimately the Supreme Court agreed that RFRA could not apply to the states. That in turn led Congress to adopt you have to have a sense of humor in seeing how these coalitions get put together, the Religious Land Use and Institutionalized Persons Act, or as those in the field call it, RLUIPA, which took that compelling governmental interest standard basically and applied it in the land use area. We can talk about that otherwise. All of that said, now, I think, Eric, with that little bit of background, which I provided for those here in our audience who may not be quite as familiar with some of these cases as those on the panel, let me ask you this question. There is, you mentioned the problem in the HHS mandate cases, which basically involves some kind of a balancing between sexual rights on the one hand and religious rights on the other. Another area where we see that same thing coming up is in the anti-discrimination field. Those who are seeking for anti-discrimination statutes. If you could draft, if you could change the statute, or if you had some guidance on what the Congress or the states might do to adopt legislation, how would you suggest balancing those interests?
Well, first, I think it's important that we think about to what extent there really is a conflict in these cases, because most of the time I think the conflict is more perceived than real. If you think about cases that have received a lot of publicity lately, the Elaine photography case, for example, in New Mexico, where a photographer, she owned her own business, a sole proprietorship. She was asked by a lesbian couple to photograph their same-sex commitment ceremony, which she did not want to do for religious reasons, and also because she felt that she could not, because of her religious objection and her discomfort, do a quality job for this couple. So, the question is there really a conflict in that situation where there are, probably literally hundreds of photographers in the area who could, who would willingly provide the service, and this woman's right to observe her own conscience. And so I think in many of the cases where these supposed conflicts come up, there's really not a conflict if we were able to adopt somewhat of a live and let live attitude where, those who want to, receive services or recognition of their same-sex union could do so, but they're not entitled to force people who have a religious objection to do that. We saw the same thing in the Chick-fil-A case, big brouhaha about this conflict with religious liberty. In reality, you had the owner of Chick-fil-A making a statement about his personal beliefs about same-sex marriage, and you had other people saying, hey, I'm not going to give my money to a man who has these beliefs. There's really not a religious liberty conflict there, as much as just free speech rights and someone's economic rights not to spend their money the way they want, until you have the government stepping in and saying, well, you had a lot of local officials stepping in and saying, well, we're not going to allow Chick-fil-A to move into our neighborhood or things like that. But those conflicts are avoidable to the extent we kind of have an attitude that we are willing to accept that other people's view of their rights is different than ours, and we have to make some compromises in our society. So I think as far as legislation, I think it would be great if every state had a RFRA statute that allowed that placed the burden on the government when it was infringing on religious liberty rights. And I think it's also important as anti-discrimination laws and same-sex marriage laws spread throughout the country that people who believe in religious liberty are active in making sure that there are protections for religious liberty in those laws. If you look at the trend of same-sex marriage spreading across the country, the early states, there were courts making decisions that were forcing the laws. No exemptions in those laws, no protections for religious liberty in those laws. Later states, it became more of a legislative matter, and as the religious liberty coalitions became more active, they worked hard to put in protections for religious liberty. I live in Maryland, which was one of the 4 states this last election where the same-sex marriage battle was lost. There are protections in the law, but they're still very insufficient. They don't protect individuals who are enter into business, for example, and have some religious conflict with different aspects of same-sex marriage being legalized. So I think making sure that people are involved and putting protections into those kinds of statutes is going to be a key going forward.
Thanks very much, Eric. In her remarks, Helen, I think, gave an insightful observation about the myth about women's rights and what really are their rights. Vaughn, if you had to explode one myth about religious liberty, what would it be? And after you, I'm going to invite Jeff and Jim to each offer their thoughts about that one as well.
We've talked a lot about this in the little religious liberty team that I work with, and I think it comes back to the cultural aspects that Jim and Elder Wickman and others have spoken about. We find ourselves in an age when people point to their identity, and sexual rights is a good one. We really don't challenge much the idea anymore that someone who wants to assert their sexual rights, that is them. It is their identity. As that movement has come along, the religious movement has suffered a corresponding setback, and that is a view that there aren't very many people around anymore who really understand what this group understands very well, that religious rights are our identity. They're not like a club we belong to that we go to on Sundays. They're not like a book club. They're not like some little hobby we have over, that we do on the side. Religious liberty is as much our identity as someone else's sexual identity might be. In fact, most of us would say that religion goes more to identity than sex does. That is a battle that we are losing. In fact, we may have lost it. It is a battle for the hearts of Americans where, without question anymore, identity is determined, and religion doesn't play a huge part in it. And that comes from the problem of, as the judges, I think, talked about, and as people on this panel have talked about, is religion declining in America and people really not understanding it. We have to find a way, and if I had a megaphone, this is what I would shout, to convince the American people that religion really is an identity, that we wear it 24 hours a day. And therefore, religious rights are just as important as sexual identity rights or anything else. We have to find a way to put those on equal footings, or we lose the debate before it starts.
Thanks, Vaughn. Jeff?
I think that there's a fundamental misconception in the country about what religious liberty means, and I think it's dangerous. And that is that I think there's a general conception that religious liberty is somehow a conservative or a right-wing or a, as some might describe it, socially backward concern, and it isn't. Religious liberty is, in fact, a freedom issue. It has to do with the, or if it's properly understood, it ought to be. It's the question of who gets to decide what your beliefs are going to be and what your practices are going to be. And I think it needs to be seen genuinely as a liberty interest and not just another way, a proxy sort of piece of language that says a right-wing interest or a left-wing or a libertarian interest, because when properly understood, it means the ability of everyone to decide for themselves in their own proper areas of control how their lives are going to be conducted and what they're going to tell the government. The government cannot direct them to do.
Thanks, Jeff. Jim, please.
Sure, I share what Jeff and Vaughn have said. I think that the idea that it's somehow this right-wing or conservative thing alone is a big problem. And what I try to emphasize to our students and in some of the reporters who have asked us about the founding of the clinic has been, who've often taken this tack. Was this conservative thing? One of our students responded to one of the reporters' questions about that and said, "Look, if this was the 1960s, you'd be asking me what's up with this liberal program." So, a lot of times people, and this is sort of a misconception about religious liberty, is so often, and I guess it makes some sense at some level, people jump right away to the religious practice that's in question. So in the HHS mandate cases, all people want to talk about is contraception, when the religious liberty question is different, is separate. And it's one that is universal, that you could apply to any religious practice, regardless of its liberal or conservative bent. That doesn't mean, of course, that the underlying religious issues aren't important and as things that we should debate and discuss. And part of this is to be able to have the freedom to then duke it out and have a marketplace of religious ideas in that sense. So it's not trying to impose any practice at all, but rather open it up for discussion. The other misconception, and I think that both Vaughn and Jeff touched on this, is this idea that religious liberty is an exception. And I think we often talk in terms of, and we fall into this, I think, as advocates for religious liberty, where we say, please let us have an exception to your rule. But that's not really the right language. What it is a fundamental right that preexists the rule that's being adopted. It's part of, once again, who we are, and built in as something before we even get to the stage of whatever the legislation is or whatever the thing that we are otherwise saying we want an exception for. In reality, it's more the law that's being passed can only go so far and cannot infringe on the fundamental right to religious liberty. Obviously, there are limits, and we're all aware of that. But as a fundamental way of thinking about it, I think that's another misconception that that we who are supportive of religious liberty also fall into.
Thanks, Jim. In fact, your last point about the exception language is another way of making the point that Vaughn has made, and Jeff as well, that we're